Tim indicated, my name is Amy Lusk. I serve as the city attorney for the city of Saginaw. And I'm speaking this morning to give council and the city boards and other commissions that are present here today and who are going to participate in the discussion following this presentation, an overview of where we're at in drafting potential opt-in ordinances for city council's consideration for adoption. So by way of background and how we actually ended up getting here in the first place, as most of you know, in November of 2018, Proposal 1 passed in the state of Michigan. It was passed by a majority of the voters, and it was codified into Michigan law as the Michigan Regulation and Taxation of Marijuana Act, or as many of us refer to it as MRTMA, because we like acronyms in the industry. What MRTMA does is two things. One, it allows for individual or personal possession and consumption of marijuana. That's the part that we here at the city can't touch. Individuals have the personal right to possess and use marijuana as they choose. The other part of it is that it allows for the development of certain adult use or recreational marijuana establishments. And that part, that's where the decision before City Council comes into play. MRTMA requires that municipalities take formal action in deciding whether to allow adult use establishments in their jurisdiction. If they take no action, technically it's considered to have been to opt in, though at this point I don't think the state is treating it that way. So last summer, in August of 2019, City Council approved an opt-out ordinance. That opt-out ordinance provides that all adult use marijuana establishments are prohibited in the city of Saginaw, but it had a 1-year sunset, and so that ordinance will sunset on August 18th of this year. That's not an uncommon approach in the state. Many jurisdictions are proceeding with caution in entering into this area. So far, 1,424 communities, city, villages, and townships in the state have opted out at present. 35 communities have formally opted in to allow recreational or adult use marijuana establishments. When council opted out, they also instructed city staff to develop potential opt-in ordinances for review, and that's where we're at today. I want to thank the city staff that have been really helpful in getting us to this point. Certainly this has not been a one-person show. I have not been bearing the brunt of all of the work. John Stempel and his staff, Janet Santos and her staff, Jeff Klopsick and his, and several others have all been instrumental in trying to put this package of ordinances together to bring forward. So what we've put together is a draft set of ordinances pertaining to marijuana use and the development of marijuana establishments in the city of Saginaw. And there's 4 different ordinances that we've drafted that are part of this package. There's an opt-in licensing ordinance. That's essentially a business licensing ordinance. There's an opt-in zoning ordinance. There's an ordinance that prohibits public use of marijuana. And there's a smoke-free parks ordinance. Now, MRTMA sets up certain requirements as to what cities can do when they're looking to adopt opt-in ordinances. They say that local ordinances cannot be unreasonably impracticable. The ordinance cannot conflict with MRTMA or its rules. They can establish reasonable restrictions on signs. They can regulate the time, place, and manner of establishment operation. They can establish penalties for violation of the ordinances, and the penalties that can be established are civil infractions with penalties of not more than $500. They can require that establishments obtain a local license. And within that licensing ordinance then, the qualifications for licensure cannot conflict with what the state requires for licensure. Cities, villages, and townships can charge up to a $5,000 fee for obtaining that license. And the city would have to issue a license within 90 days of application. MRTMA does also contain some prohibitions as to what a city can adopt within their local ordinances. And it prohibits the city from adopting an ordinance that prohibits transportation of marijuana through the city. So even if the city were to remain opted out, the secure transporters that are licensed by the state still have a right to drive through it to get to establishments in other jurisdictions. And we cannot prohibit the co-location of facilities or establishments. So essentially, if a developer holds multiple licenses, if they stack growers' licenses, they can co-locate in one establishment. So far, the draft licensing ordinance prohibits unlicensed operation of adult-use marijuana establishments in the city. The language of the draft provides for growers, excess growers, processors, retailers, secure transporters, and safety compliance facilities to all be allowed, potentially, licensure within the city. However, it does still specifically prohibit micro-businesses, designated consumption establishments, marijuana event organizers, and temporary marijuana events. The last three of those types of establishments are actually things that were not contemplated by the act that the voters voted in 2018. Those were established by the state when the state issued its emergency rules. And it's not uncommon for even those communities that are opting in to remain opted out of those particular establishments. I realize it's a little bit hard to read, but if you take a look at the right side of the column, you'll see that even those communities that have formally opted in to allow establishment in the state remain largely opted out of temporary marijuana events, designated consumption establishments, and the like. So other provisions of this draft ordinance establish a variety of different criteria. It establishes the application procedure and the contents of what needs to be included within that application. And that procedure and those contents essentially mirror what an applicant would be filing with the state. They'd have to file their marijuana establishment plan, their security plan, a ventilation system plan, staffing plan, and marketing plan. It provides that there will be an annual license fee that will be established by council. The ordinance will set up a basis for the denial of applications. For example, if someone applies for a license and they don't have all of the zoning matters in place that they need to have in place, that would be a basis for denial. It establishes the issuance of a provisional license. In simplest terms, applicants would go to the state, pre-qualify, come back to the city, apply. The city clerk's office would do a cursory review to make sure that the application is complete. They can sign off on the attestation that has to go back to the state, issue a provisional license. The applicant then gets fully qualified and licensed from the state and comes back to the city for full licensure there. The ordinance establishes criteria for revocation of a provisional license. For example, if someone doesn't end up obtaining their state license, that would be a reason to revoke a provisional license. It establishes requirements for an issuance of a marijuana establishment license itself. Provides for annual renewal, when amendments to licenses, like change of ownership or other things might be required. Provides, just like providing a basis for revocation of a provisional license, it provides the basis for revocation of a marijuana establishment license. Again, for example, if someone lost their license with the state, they would in turn lose their license with the city as well. It provides appeal rights for individuals who might have their licenses revoked. It sets up minimal operational standards for each type of establishment that correspond with those minimal operational requirements that are MRTMA. And again, it establishes those penalties, which under our ordinances would be a Class E municipal civil infraction, which I believe the fines start lower than 500, but progressively after so many offenses would become a $500 fine. We also have an opt-in zoning ordinance. And now the two ordinances, the licensing and the zoning ordinance, go hand in hand. So essentially, council would have to pass one for the other to be effective. If for some reason the zoning ordinance didn't make it through the planning commission and didn't get passed, then the licensing ordinance would not take effect. But again, MRTMA establishes certain requirements as to what cities can regulate within their local zoning ordinances. It provides that marijuana establishments cannot be within an area exclusively zoned for residential use. And it provides that marijuana establishments cannot be within 1,000 feet of a school unless a city takes specific action to reduce that distance. So our draft at this point establishes zoning classifications in which each type of establishment is allowed. It establishes review and approval procedure for each type of establishment based on the level of development. Planning Commission approval in accordance with its special approval powers under the zoning code is essentially needed for any new development and for larger scale expansions. And then smaller scale expansions will require chief inspector approval for conformance with building and zoning regulations. The draft zoning ordinance also establishes separation distances from certain sensitive uses, including schools, churches, parks, and those sort of land uses. So this essentially provides an overview of the type of establishments that are allowed, the review criteria, whether it needs to go through Planning Commission or whether it would require chief inspector approval, and the zoning classifications that those establishments are allowed in. Simply, all establishments are limited to industrially zoned areas, with the exception of retailers, which are additionally allowed in our B2 and B3 commercial districts. And again, I want to thank Jeff for his assistance in preparing this. This map provides an overview then in taking a look at the sensitive uses we've delineated within the draft zoning ordinance, such as schools, churches, and the like, and taking into account the zoning classifications where various development would be allowed, again, industrial or B2, B3 commercial. The highlighted areas show potential areas of development for where marijuana establishments could be allowed within the city of Saginaw. The orange areas and the red areas are primarily those industrial areas. Again, and I apologize for those in the back, a little bit more difficult to see are the commercial areas, but certainly significant potential commercial developments in the green and the blue. You'll see a lot of that popping up along Gratiot, some of it along Court Street, Genesee. Jeff, can you help me out of what other areas we saw a lot of that available?
No, I think you have it, like Court Street, Genesee, and.
State Davenport. Yep. So other provisions of the draft zoning ordinance include, again, application requirements, operational requirements, including exterior appearance, lighting, video surveillance, ventilation, odor control, and the like. Again, those criteria essentially lining up with what's allowed under the act and the state rules. It prohibits drive-through or mobile establishments. It provides that retailers may be open from 9 to 9. It prohibits on-site consumption. And again, it establishes a penalty for violations that mirrors that in the draft licensing ordinance, a Class E municipal civil infraction. The third ordinance that's in this draft packet is the Prohibition of Public Use Ordinance. So the act does not specifically prohibit public use. What the act says is that the act does not authorize consuming marijuana in a public place. So the city has put together an ordinance specifically prohibiting the consumption of marijuana in any manner, including smoking, in a public place. Violators are deemed a public nuisance, and violators are responsible for a Class C municipal civil infraction. Of course, the ordinance does not supersede any individual's right to consume on their private property or an individual's right to use marijuana for medical purposes as that's allowed by law. And finally, we put together a smoke-free parks ordinance, and this is something that's actually been discussed amongst city staff and various members of city council, both past and present, for a number of years, and it just seemed like the right time to bring a draft forward when considering all of the other ordinances that are potentially being looked at. The smoke-free parks ordinance provides that no person shall be allowed to engage in smoking in any city park. So that includes parks, playgrounds, tennis courts, community centers, or outdoor athletic complexes and the like. Smoking is specifically defined as possessing a cigarette, e-cigarette, cigar, hookah, or pipe that contains tobacco, marijuana, or any other product that is lit or burning, lighting a cigarette, e-cigarette, and the like. And violators are responsible for a MCI, which is a municipal civil infraction, with a fine of not more than $50 or community service. And so finally, what are our next steps in looking at this? I don't want to give anybody the impression that these draft ordinances are complete. They are not. We are still in the process. This is a highly intensive process. It's about 30 pages of ordinance right now. And we're in the process of still continuing to finalize that ordinance language. It's one thing for me to write it, but then it really has to go to city staff for their complete review, because they're the ones who are going to be put in the position of implementing and enforcing these ordinances. So they have to fully understand and be invested in the language that they contain. There's also the creation of background documents and programs necessary for the implementation of the ordinances. We have to set up applications, we have to set up permitting procedures, not only the paperwork portion of that, but the infrastructure within the IT area that's gonna be playing in the background. Again, staff has to develop their own internal processes as to how they're going to handle it when applicants come in with applications, and what they're going to do and how they're going to manage those, what their steps are gonna be. We have to determine what fees are gonna be charged. The act allows the city to charge up to a $5,000 fee, but it's a fee. It is not a tax, so any fee we charge has to correspond with the cost of the work involved. Once we get all of those things in place, then the next step in bringing the ordinance is to take the zoning ordinance to planning commission, because planning commission would be charged with reviewing any amendments to the zoning ordinance. And then finally, if that passes through planning commission approval, they come to council for introduction and adoption.